So for the trusts, I've just got a diagram here for what we do with our trusts. And essentially, the settlor is you. That's the person who's making the trust. The corpus is the cup that we're putting all the trust assets into. The trustee is the person who decides who drinks from the cup. The beneficiary is the person who drinks from the cup. And the remainder is when the person has died, the beneficiary has died, that's who it goes to in the end. So how do I use testamentary trust? So there's two kinds of trusts. There's trusts you set up while you're alive, and then there's trusts you set up in your will, and those are testamentary trusts. I like to set up testamentary trusts if we're in a situation where I want to benefit my partner for their life, but I do want my assets to go back to my family or my children or a charity. So we set up a trust that says, pay money to my partner while they're alive, and then upon their death, whatever money's left goes here. Now we set up special rules in that trust. We say either pay all the income or pay X percent per year, or pay X dollars per year. It depends on the situation. That's where this is art and science. The science is I'm given a set of rules by the government. The art is how I paint the picture with those rules. I like to also set up trusts if we have children to benefit them while they're still irresponsible. So if you leave to children outright, so say you've got nieces or nephews, you're just going to say, oh, I'll leave a little bit to them, or your child, you want to just leave everything to them. Well, unless we put in special language, that child and the executor of the will hold those assets till that child is 21, and then at the age of 21, that child gets everything. So I just want everybody in the room to think for a second, what would you have done if you inherited an entire estate at the age of 21? Mm-hmm. Right. So I like to put in a couple of different clauses. I like to put in something saying the executor will hold it till they're 25 and then distribute it. I will often put in, if we're dealing with larger amounts of money, the executor will hold it until, or we'll create a trustee. We'll pick somebody who will manage this trust that we're going to create, and they're going to discretionarily spend till the child's 25, so maybe for education, travel, etc. At 25, we'll give them income from the trust. At 30, we'll give them a portion. At 35, a portion. And finally, at 40, all of it. That's where you often hear the trust fund hipster term, because they're living off the trust income until they're of age. The revocable living trust that I talked about is the trust that we create while we're alive. It's a trust for trust law purposes, but not tax law purposes. It uses the settlor's identification number. And we use that to avoid probate when we have assets in another state, so we don't have to go to other states and say, hey, I had something here, let's practice law out of New York State and get it into New York State. We use it when there are less than ideal family dynamics. So we anticipate a will contest. And a really neat thing about the revocable trust is that we can change our mind as much as we want and just execute new amendments to the trust, as opposed to doing new wills or codicils to will. It's very easy to just do a restatement of a trust or just an addendum to the trust and change certain clauses when life situations change. Yes? Yes. Upon your death, yes, upon your death, the trust gets its own identification number and needs to be administered according to the terms of the trust. However, it does not go to the probate court, which is what we want to avoid. People don't have standing to come in and challenge that trust. Your lawyer just basically administers it. It's smart. It's smart. There's a cost up front, but the amount of money and the amount of hassle that it saves down the line is exponentially exceeds whatever the upfront cost would be.